So welcome everyone. Thank you for joining us today. My name's Alicia. I'm one of the co-leads of the Law and Policy stream at the Centre for Protecting Women Online. And you're joining today our seminar on assessing the limits of Canadian civil recourse for non-consensual distribution of intimate images with Jane and Ghania here joining us from the University of Ottawa. So there will be, just to flag a few things before we begin, some of the content is going to be distressing, so if anyone would like to take breaks during it, you're more than welcome to jump out and jump back in. This is also going to be recorded as well, so if you'd rather watch the content later on, you're more than welcome to do that. If you do have questions during the seminar, please use the Q&A function at the top of Teams. You can see it's next to the chat function. And to give our speakers more than enough time, I'm going to pass on to them now. So please, Jane and Ghania, look forward to hearing you speak.
Thanks so much, Alicia, and thanks to the Centre for inviting us to give this webinar. We're going to be obviously focusing on Canadian civil litigation case law relating to non-consensual distribution of intimate images, or NCDI. This is very much a work in progress, so we're looking forward to your feedback and to our discussion afterward. Our plan is to talk for around 35 to 40 minutes and then open things up for conversation. Questions can be posted in the Q&A. The agenda is I'm going to give a short overview and then we'll get right into Ghania talking about how harm and intimate images are understood in the case law we looked at. Then I'll talk a bit about how the case law treats consent and reasonable expectation of privacy, and then turn it over to Ghania for a few going forward remarks before we get into the Q&A. So just to get into the overview a bit, non-consensual distribution of intimate images, of course, is a form of tech-facilitated image-based sexual violence. It has been a specific criminal offense in Canada since 2015. Studies indicate that it disproportionately harms cis and trans women and girls. Although men and women may be targeted at equal rates, images of women are more likely to be widely distributed. Women are more likely to feel pressure to provide images in the first place and to suffer more insidious harms, with a significant portion of reported cases involving young people. In police-reported incidents in Canada, most perpetrators were male and most victims were female. It is a prevalent form of intimate partner violence, but it's also something that's occasioned by strangers after incidents of voyeurism and upskirting, for example. Police-reported incidents are growing year over year, and that's likely only a fraction of the actual incidents because most cases are not going to get reported to police and don't actually result in anybody seeking a civil remedy. We do, however, have civil remedies available now in Canada. There's legislation in all provinces except Ontario, and none of the territories have such legislation, though it is under consideration in the Yukon, and the Law Commission of Ontario is looking at the issue as well. Within provinces that have legislation, there's a variety of things that happen. Sometimes it's specific intimate image protection legislation. Sometimes it's intimate image protection that comes within an existing privacy statute. And in other cases, especially in Ontario, where we don't have legislation, it's common law torts like public disclosure of private facts and intrusion on seclusion. Our comments are going to primarily focus on the statutory regime. Just to give a quick overview of some recent legislation or legislation that's been amended recently in British Columbia, Manitoba, and Quebec. What's interesting about the BC legislation, or one of the interesting things, is that it can be resolved by a civil resolution tribunal as opposed to a court, which provides an expedited process. The damage limit has been increased to $75,000 recently from $5,000. And so all of these pieces of legislation allow for damages. They also allow, importantly, for quick removal processes. And then they deal differently with whether or not synthetic images are covered. And that may be something that we'll come back to in later conversation. Some of these responses were amendments or changes or implementations were a response to recommendations by the Uniform Law Commission of Canada in 2019 to recommend that Canada have a more uniform approach. I'm going to turn now to say a bit about our method here. We did a review of reported decisions in online databases, as well as the BC Civil Resolution Tribunal's own decision database. We found a total of 55 cases from 7 jurisdictions. As you see in the left-hand graph, 69% of those cases were from British Columbia, likely as a reflection of the fact that they have this expedited review process. On the right, in the right graph, you see a gender breakdown. Overwhelmingly, cases had female plaintiffs and male defendants. The financial compensation, which isn't depicted here, is a range anywhere from $3,000 to $160,000, depending on the regime under which relief was sought. Obviously, again, reported decisions don't reflect anything close to what the scope of the actual problem is, because most cases don't lead to civil litigation. And for those that do go to civil litigation, many are settled without a final reported determination. So with that sketch in place, I'm going to turn it over to Ghania to talk about a case law approach to harms and the definition of intimate image.
Thank you, Professor Bailey. So I will be talking about how the courts and the tribunal understand harm in civil case law. So in terms of harms, courts have acknowledged it as being very severe and have drawn comparison to sexual assault cases, highlighting that it's a sexual and policy violation. Courts have also highlighted the prolonged and recurring harm of images being on the internet. So images could be copied, reobserved, and republished, resulting in harm manifesting over again. So as they say, the internet never forgets. The harm can also bleed from online to offline, manifesting to harms that can impact someone in person. So survivors have said that they lost the right to control who sees their body, and they never know which passerbys have seen the images. Additionally, they can and have been contacted by strangers who wanted to buy sex from them. So the court has acknowledged the away from keyboard harm, and this is important that they've acknowledged this in NCDII cases, because as we all know that when NCDII is reported, the harms are not taken seriously. Before discussing the different types of harm, it is important to recognize that there is an immense psychological harm that survivors experience. And psychological harm such as mental distress, nervous shock, depression, anxiety, and sleep disturbances can impact other aspects of people's life. I wanted to draw attention to one case in particular coming from the BC Tribunal. So in AK and BT, AK is a trans woman and BT is an anti-trans activist. The image that BT shared had the court stated had a clear purpose of depicting AQ as a man. And so this was an image that was altered to show AQ's head on a masculine body. And in this case, the tribunal stated that that the image was harmful, not because it was explicit or graphic, but because of the anti-trans context associated with it. And that the image itself dehumanizes AQ and denies her gender identity. So as such, the tribunal acknowledged the offense to AQ's dignity and that it was a distressing image to be uploaded online. Next slide. In terms of harm, the courts have addressed the wide range of harms that stem from NCDII, so including impacting someone's education, career, and interpersonal relationships. So in terms of education, survivors are not able to attend classes and school due to mental and psychological harms. Their careers are also impacted. And given that the image can resurface or be re-uploaded, it can impact their current employment and also future prospects. In most cases, NCDI was uploaded by someone the survivor trusted. So as such, the incident can impact a survivor's trust and feelings of safety, especially when something that may have been a moment of celebration of their affection or sexual attraction for another person is used against them. And so survivors have stated that they're unable to have romantic relationships, unable to trust others, including friends. Additionally, survivors with children also worry that their children's safety and information of their NCDII can be used against them to harm their children. So although the courts have recognized a wide range of harms, the harms are not representative of everything, especially it does not represent harms that are experienced by marginalized people, which I will go into further later. But this failure to recognize harms can stem from lack of acknowledging images and videos as intimate and deserving of privacy. And I will further discuss this in the next section when I talk about intimate images. So before I get into the shortcomings of the definition of intimate images, I'm gonna give like a brief overview of how the legislation across Canada define intimate images. So in all legislation across Canada, there's two components that are needed for an image to be an intimate image. So the person needs to be either nude or nearly nude and engaging in a sexual act. So in terms of this definition, an applicant needs to be nude or nearly nude in order for the image to qualify as an intimate image. And this means two things. The person has to be not wearing much clothing, and the context of the image is important. So the image needs to be taken for sexual or private purposes. Additionally, nude in the case law has been meant to say completely bare. So in a case, BDS and MW coming out of the BC tribunal, the respondent shared an intimate image of the applicant with a third party on X, and the tribunal found that the applicant was not nude because the applicant was not completely bare. So now moving on to the shortcomings of this definition. As mentioned before, the court has taken a very specific perspective, specifically a Western perspective. So as such, the provision is not used to capture violations that can't be understood from a Western perspective. So there has been two cases from BC where the applicants were hijabi women, and the tribunal stated that the images did not qualify as an intimate image because the women were not nude in the images. However, in SO and AZ, the applicant, who's a hijabi woman, said that as a Muslim, to her, there's no distinction between physical nakedness and unveiled exposure, and that the images of her without her hijab are comparable to physical nakedness. In both cases, the applicants also state that the respondents knew the importance of hijab to them and submitted the photos in an attempt to humiliate them. So in these cases, the veil functions as a private space, and it is a boundary of not trespassing, and that extends on to the public space. But unfortunately, so far, the tribunal has not adapted their definition of intimate images to, I guess, fit the non-Western perspective of intimate and privacy. The other component needed in order for an image to be an intimate image is a sexual act. The courts define sexual as something more than kissing or a peck. And this definition can also limit recourse for applicants. So in IB and AZ, a case where the applicant was a hijabi woman, the tribunal stated that the image did not depict the applicant engaging in a sexual act because the image appeared to depict a peck, and there was no indication that the kiss was prolonged. However, it's important to acknowledge that intimacy can mean different things to people. So the court's conception of sexual intimacy has to be open to understanding that sexual intimacy means different things to others. So in order to address these shortcomings, especially with the definition of intimate images, we suggest that the courts either that legislatures either implement legislative amendments, so either by broadening or addressing the different conceptions of intimate. And in terms of interpretation, we recommend using Section 15 as an equality interpretation when assessing whether an image qualifies as an intimate image. So Section 15 of the Canadian Charter of Rights and Freedom guarantees equality under the law and equal protection, and it is interpreted as a substantive equality, so focusing on the actual impact of law. So we suggest that by using Section 15 as an equality interpretation, the courts can ensure intersectional identities are being considered in their conceptions of intimate images and types of harms. Now I'll turn over to Professor Bailey to talk about consent and reasonable expectation of privacy.
Thanks, Ghania. Consent obviously is core to the case law because the focus is on whether a distribution was non-consensual. And we see robust conceptions of consent similar to those adopted in Canadian criminal sexual assault law in the NCDI context in a couple of ways. First, the case law either impliedly or in some cases expressly adopts those robust interpretations from sexual assault law. And secondly, we see robust interpretations codified in different pieces of legislation. So in terms of the adoption of the robust approach in case law, criminal sexual assault law on consent indicates a number of things, and I'm going to highlight a few that are referred to in the NCDI law, case law that we looked at. Contemporaneous is one of them. That is that consent must be given contemporaneously with a sexual activity in question. In the Alberta case of Grummet, the defendant had argued that past discussions and behaviors relating to the plaintiff had established consent for to the current distribution that was at issue in the case, and the court rejected that argument, plainly stating that past consent is not current consent. Moreover, the court in the same case also dealt with the issue of rape myths, relying on prior Supreme Court of Canada authority in CPWO, which held that use of a complainant's prior sexual history for proof that they were more likely to have consented to the sexual activity at issue in a case was not acceptable and was premised on rape myths. Grummet used the same logic to say that past sharing of intimate images with a person didn't lessen the privacy interests at stake, nor the severity of the potential harm of the non-consensual disclosure of the image in the case at hand. Finally, consent has to be specific in the sense that it has to relate to each sexual act. So agreement to one sexual act, that is, for example, having sexual activity recorded, cannot be presumed to be agreement to another sexual act, such as the distribution of that recording. And this was referred to in a number of cases in a few jurisdictions. We also see approaches to consent being codified in specific NCDI legislation. And here I'm going to highlight a couple of examples. The Saskatchewan Privacy Act, which has provisions relating to intimate images as well, imposes a reverse onus. So it presumes that distribution of an intimate image is without consent unless the defendant can establish reasonable grounds to believe they had ongoing consent for distribution. Another example are statutory provisions that explicitly state that a reasonable expectation of privacy is not lost just because a plaintiff consented to the recording or shared it with another person, as long as the recipient knew or ought to have reasonably known it was not to be further distributed. So we see the legislation pushing decision-making away from assuming that prior consent to recording or sharing should necessarily be equated with having lost a reasonable expectation of privacy in an image. So let me turn then more directly to REOP. It comes up at 2 points in the legislation. You have to show there was an expectation, a reasonable expectation of privacy at the time of the recording and at the time of the distribution complained of. Typically, the presence of an REOP will be part of the definition of what makes something an intimate image that is protected by a piece of legislation. To evaluate the approach to expectation of privacy in the civil case law that we looked at, we are centering the work of Moira Aikenhead, who argued in an excellent 2018 article that equality-affirming outcomes in this context are going to require courts to take a normative feminist approach to reasonable expectation of privacy that does two things. First, it understands privacy not as being about shame or secrecy, but as a facilitator of self-determination, bodily and sexual integrity, and autonomy. And secondly, it has to take into account socio-technological realities that may complicate prior understandings of things like the lines between public and private spaces, that recognizes and treats with respect the reality that consensual sharing of intimate images can be a healthy part of sexual interaction, expression, and exploration, and should not be something that attracts a victim-blaming logic. And at least to some extent, the Supreme Court of Canada in the Jarvis voyeurism case offered an approach to reasonable expectation of privacy that begins the work of building that kind of account. And I'll say more about Jarvis later. So we use this normative framework to assess interpretations of reasonable expectations of privacy in the case law, and noted first that courts do refer to the fact that privacy, especially intimate privacy, is important and connected with autonomy. For example, in a 2018 Jane Doe decision, which was a tort-based case, Justice Gomery noted, "It's difficult to conceive of a privacy interest more fundamental than the interest that every person has in choosing whether to share intimate or sexually explicit images and recordings of themselves." And the judge went on to say that a cause of action that protects this privacy interest is rooted in our deepest values as a society. This is similar to the Supreme Court of Canada's statement in Jarvis that privacy and information about our sexual selves is sacrosanct. So all of this is encouraging. But when it comes to the case law generally, there weren't a lot of published decisions where the decision maker went into great detail about whether a reasonable expectation of privacy had been established. And that was often because it wasn't necessary on the facts. Sometimes it was also part of an analysis that was referred to that was in an unpublished decision about a protection order. But those where there was express discussion came predominantly from the BC Civil Resolution Tribunal. And in reviewing those decisions, we noted three areas of concern, not necessarily because we disagreed with the conclusions on the facts of each case, but because it raised concerns for us about how reasonable expectation of privacy might be addressed in other cases involving similar issues or fact patterns. And those involve three things. First, unsolicited images. Second, workplace recordings in the public interest. And third, previously posted images. So in terms of unsolicited images, I'll refer to the case of AA and BB as an example. In this case, the claimant had sent intimate images to her former music teacher after the music teacher's employer had terminated her lessons. The music teacher had shown the images to his employer, and those images had in turn been shared with police in relation to a harassment complaint. The tribunal said the employer's disclosure to police was lawful as part of a criminal investigation, which is provided for under the legislation. But it also said the student had no reasonable expectation of privacy in the images when shared with the teacher. In deciding that, they used a multi-factor approach, and they referred to the Supreme Court of Canada authority in Jarvis, but they added this particular criterion: what the sender might reasonably expect the recipient to do with the images. They found that it wouldn't be reasonable for the student in this case to expect privacy when she sent the image to her teacher, in part because the act itself makes it lawful to disclose intimate images for purposes of a criminal investigation. Our concern here is that this imposes a risk-based analysis, and I think we'd want to question whether every time someone shares an intimate image that isn't solicited, that there is a risk that it will be disclosed to police. and how much we should be thinking about other Supreme Court of Canada authority that suggests we should generally be able to expect communication with others to be kept confidential. And I also wondered whether sufficient weight was being given to the intimate nature of the image here, which we would argue should be in a multi-factor analysis one of the most heavily weighted factors. This is not to say, surely, that every unsolicited image, particularly one that was known or ought reasonably to have been known to be unwanted, necessarily garners a reasonable expectation of privacy. That's for certain. But that a more nuanced analysis may be needed here. We see the potential for another type of risk-based analysis in the context of workplace recordings and the public interest exception. In MR and GW, intimate images that employees had taken in the workplace and then shared with a partner were later disclosed to their employers. In MR's case, it wasn't apparent that there was any pre-existing concern about her having engaged in workplace misconduct, but the tribunal still concluded that she had no reasonable expectation of privacy at the time it was disclosed to her employer, and noted that the defense of public interest applied. That is, that there was a public interest for the photos to be disclosed to her employer. In GW's case, the image was disclosed after an investigation was started due to a complaint of inappropriate conduct, and the workplace was a public hospital. So there was a slightly more nuanced analysis of why the public interest was triggered. Just concerned here that a different standard of reasonable expectation of privacy might automatically be applied to workplaces. And we'd want to question any assumption that that's necessarily the case, or that there's necessarily always a public interest for images taken in workplaces to be disclosed. Finally, prior posting and waiver. I'll look at the case of AQ, also a BC tribunal decision. The tribunal held AQ did not have a reasonable expectation of privacy in an image by the time BV posted it on Substack, because before that time, AQ had posted the image on X. The tribunal found that promoting individual autonomy over intimate images was important, but noted the legislation specifically only protected images in respect of which one has a reasonable expectation of privacy, and held that it wasn't reasonable to expect privacy in relation to an image that had already been posted online, noting, I find that by posting an image in a public place online, an individual forfeits any reasonable expectation of privacy over that image. Again, what we're not trying to say is that you always have a reasonable expectation of privacy in an image that's posted online, or that the conclusion in this case is necessarily wrong. But we do think a more nuanced contextual approach is needed from a socio-technological point of view. Because, for example, I think we can see there is a very real difference between a performance artist posting a semi-naked image of themselves on an arts-based website or portfolio site, and someone else copying that image and posting it on a porn site where it's taken out of context and given a very different meaning. So at minimum, we think we need a more nuanced approach to reasonable expectation of privacy, but perhaps if autonomy and self-determination are our key objectives, we might consider whether reasonable expectation of privacy is a requirement that is necessary for purposes of civil redress. And I'll turn it over to Ghania to talk about going forward points that are mainly geared, I think, toward intimate image statutes and potential reforms.
Thank you, Professor Bailey. So lastly, I'll just reiterate our recommendation based off of our findings and analysis. So for harms, we want the court to expand its understanding of harm by adopting an intersectional approach to harm. Additionally, the court's interpretation of intimate images needs to center intersectional understanding of what it means to be intimate. Additionally, the legislation should also consider either broadening or addressing intimacy, different perspectives of intimacy. In terms of consent, we suggest a robust interpretation of consent from sexual assault law. And for reasonable expectation of privacy, we recommend either removing the requirement of having a reasonable expectation of privacy or establishing a more detailed normative feminist approach grounded in bodily and sexual integrity, autonomy, and self-determination. With that concludes our formal presentation part of the presentation. And I think we'll move on to questions.
Thank you both so much. That was so interesting. I have made a considerable amount of notes, I'll be honest. So we've got some questions coming in the Q&A, so I'll just mention again, if anyone has got any questions, can you please use the Q&A function in Teams rather than the chat. But to get us started, so Layla's posted, Layla Brown, who's the other co-lead of the Law and Policy stream at the Centre, has posted a question about your mention of Section 15 being used, whether you've seen any uptake of Section 15 being used or applied in case law with regards to it applying a more intersectional approach to what can be considered intimate or harm. And if you have, has it been successful and widened understanding, or if you haven't seen an uptake of it, do you think there are any challenges with judiciary uptake?
So I guess I can start off by answering that, and then Professor Bailey can chime in. So we haven't seen any example or cases of tribunal or the courts using Section 15 specifically for NCDI. And I guess that is because the intimate image definition is quite restrictive. As I stated, nude, barely nude, and sexual act. And the way that they define that is also from a specific perspective as well. I will mention that in one of the cases from BC, the tribunal does acknowledge that during the discussion of adopting the NCDI legislation in BC, there were discussion of, taking a marginalized or intersectional approach of intimate images, but ultimately the tribunal stated that the legislation decided not to include that in their definition of intimate images, and as such, the tribunal would also not consider that.
Yeah, and I would just, what I would add about Section 15 is more a more general observation. So I've been involved, I was involved in a voyeurism case where we did bring forward a Section 15 argument about how the interpretation of the requirements of voyeurism needed to be done in accordance with Section 15, in accordance with equality, on the basis of the understanding that this was a crime with gendered consequences. And Section 15 is not necessarily well received even by the Supreme Court of Canada in those kinds of arguments, which is definitely not an argument for not doing it. I think it needs to be done. I think what we need to do is familiarize, make decision makers more familiar with Section 15 rather than less. It's just a caution to note it's not always the easiest provision to deal with when you're trying to push for a certain kind of interpretive approach. That said, I absolutely think that it's something that's certainly available and should be thought of. It's tough in the civil resolution tribunal cases, for example, because it is giving an expedited process that's maybe potentially often more informal and doesn't necessarily require a lawyer. And making a Section 15 argument is probably something that's going to have to involve some form, I would think, of test litigation, someone who's willing to have their case used as a test case for that. But I do think there's room for that, and I think it's important.
Okay, that's really fascinating. Just following up on that, then what do you think with the considerable issues around how intimacy is defined and then the knock-on effects of that? What do you think are the next steps? Is it potentially expanding the use of Section 15 in this way, or do you think there are any other avenues that you potentially are more straightforward or more easily applicable? Like, how do you envision like going forward in that space?
I think we've had a lot of discussions in terms of, oh, what is the appropriate approach? Is it broadening the definition of intimate images? Is it broadening the interpretation of the definition? So I don't think we have, well, personally, I don't think I have a clear opinion on that. But I will say, as Professor Bailey mentioned, that the Law Commission of Ontario is currently working on a potential intimate image legislation proposal, and I think that gives Ontario space and room to think about these issues because there is no current legislation. So thinking about how do we define intimate image, whether that is broadening the definition or broadening the interpretation. And I think Ontario could be used as a good example if these things are considered for the other provinces to follow suit.
Yeah, I think that's a really important observation. It's very frustrating that Ontario has waited so long, but on the other hand, we now have the ability to look at what's gone before and how things are going under those pieces of legislation. Because in many ways, decision makers they do have to interpret the law as it's written, and yes, they have to give it full effect and they have to take into account Section 15 and equality interests. That's absolutely true. But if the legislation itself either changes the definition of what constitutes as intimate, or it somehow directs decision makers to be paying attention to the fact that individual applicants may have different perspectives that are grounded in religion, sexual identity, gender identity, that also should be taken into account. Just that sort of direction to allow them the leeway to recognize that the legislature accepts that they should be thinking in those terms as well.
So we've just had another question come through from Annie. Do any of the laws capture manipulated images that do not necessarily appear authentic? If not, do you think they should?
Yeah, so that's the whole issue of I guess synthetic images or deep fakes, or I mean, there's such a range. The first thing I want to do is to shout out to Susie Dunn. It's a case. She has an article called "Legal Definitions of Intimate Images in the Age of Sexual Deepfakes and Generative AI." It's a 2024. It's in the 2024 McGill Law Journal, which is a very comprehensive analysis of the Canadian legislation at that point in time. And I guess at the end of the day, so some legislation doesn't even seem to account for manipulated images at all. And right now we have a proposal to amend our criminal code provision to include deep fakes. Others allow for coverage of altered images, and it isn't entirely clear what fits under altered image, whether it includes an entirely synthetically generated image, or whether it always has to come from an original image of an identifiable individual. And then more recent legislation, the Manitoba legislation, was amended by the Distribution of Fake Intimate Images Act. And it involves any type of visual recording that, and then to use the words of the question, in a reasonably convincing manner, falsely depicts an identifiable person engaging in explicit activity or being nude, exposing genitals, so forth. And it specifically refers to the image being made with the use of software, machine learning, artificial intelligence, or other means, and it includes modification, manipulation, or alteration. But it has to be reasonable to suspect that the person depicted in the image would not consent to the recording being made or distributed to others. So there's a whole spectrum in terms of how synthetic images are being treated. But now to the particular question, should what do we do with reasonably convincing? Well, there was a provision in the current proposed amendment to the criminal code that qualifies the coverage of a synthetic image by saying something to the effect of it's something that when looking at the image, it essentially reasonably make a reasonable observer think that the person depicted was engaged, that it was real, in effect. And I'm part of the Technology Facilitated Violence Advisory Committee on the Women's Legal Education and Action Fund, and in their submission, they argued that that section of it needed to be removed because it's too simple to generate an image and add a unicorn horn so that people would say, well, we know now that we're looking at this that this isn't real in that sense, in the sense that when we're talking about real, and that still has all the same impacts on sexual integrity, bodily integrity, and so forth that an image without that kind of addition would have. And so the argument is that that those provisions should be that provision should be removed. It doesn't have to be that it would convince you be convinced that this is a person engaging in that activity. I don't know if that answers the question.
No, thank you. So we've had another question come in from Lauren. So in cases of non-consensual intimate image reporting on digital platforms, organizations may need to temporarily retain illegal material as evidence. How does Canadian law reconcile the tension between possessing such material for evidentiary purposes and the risk of committing an offence? And what responsibilities do organizations have to protect victims during that process?
I'm going to have to say that I don't have specific expertise on that, but I can tell you something related, which is that we currently have a bill about maintaining and disclosing information to law enforcement authorities, Bill C-22, that's quite controversial in this sense for a number of reasons, including that it seems to take private actors and make them, deputize them as extensions of law enforcement, which is concerning. So I know that I know that that's out there. We've also had very recently a really tragic situation, I think probably known around the world, about Tumbler Ridge, where a young person used ChatGPT and then eventually committed a mass shooting and was also killed. And it came out that there had been searches on ChatGPT that were concerning, and that OpenAI had known about it and had not reported it, even though at one point they had cut off her account. So that is a very live question, because the whole question is, what is it we want service providers to be doing? And what do we know about what they are doing? And how do we hold them accountable for that? And there's so much work to be done on service provider accountability, transparency, and also some really hard thinking about how much more surveillance, other than what they're already doing for their private for-profit purposes, we want them to be doing in the name of law enforcement. So that's all. That's what I can add to that. And yeah.
Yeah, on that latter point, I think it's really interesting looking at the balance between putting legislation or policies out in the name of getting these corporations, which have created these products, to monitor their platforms more, but in the way this is it's dressed up as that, but it's actually surveillance. Is there anything else you wanted to speak on about that? Because there's also that concern around how it usually will end up being over policing marginalized people. A lot of people rely on different VPNs, for instance, is a conversation that comes up in the UK quite a lot. A lot of marginalized people, at-risk people, rely on these tools. So is there anything else you wanted to mention with regards to that?
Yeah, that's just it. That's, I think, the most important point, that anytime that we're involving law enforcement, we really do have to be thinking about the degree to which marginalized communities have very strong historic and current reasons not to trust law enforcement agencies. And I know law enforcement agencies in many jurisdictions are working to change that, but there is a systemic problem there. And so we really do need to be thinking about that. That has to be front and center any time that we're considering these issues. And the other thing I'll say is I do find it frustrating that what happens is when something happens after the fact, then we look back and the solution is let's engage private service providers in more surveillance. And then we never get to have the public debate about, well, how did we get here in the first place? How did the absolute vacuum in regulation that allowed this kind of technology to be just unleashed on the public, when any sort of any minimal amount of substantive equality analysis or understanding of structural discrimination would have recognized who was likely to be disproportionately affected by its harms. And until we can have those prior conversations, we're always going to be doing this reactive stuff where suddenly the first thing we do is deputize the corporations to keep us safe, when we have a whole lot of reasons to believe that they, without some pretty express instructions, don't necessarily do a very good job of that.
Yeah, just adding on to that, I think the issue itself is the business model that a lot of these corporations have, is that they're getting money by the algorithms and by perpetuating violence online. So yes, we do need to take a reactive approach, but we also need to be proactive in terms of addressing these business models that encourage violence. And even when there is a reactive approach, oftentimes corporations, do not follow orders, or they have the resources to fight in court. There is a case from the BC Tribunal of X. Not taking down someone's intimate images, instead just geofencing them, so anyone outside of Canada cannot see it. And because X did not follow that protection order, the tribunal, I think tribunals, was it $100,000 for not complying with the protection order, but X is fighting that order, and and they're arguing that geofencing is enough, that geofencing the image in Canada follows what was asked of them in the protection order. So I think there needs to be proactive changes, but also I think in terms of reactive changes, oftentimes the corporations have the resources, the money, the lawyers to fight protection orders.
Yeah.
Yeah. There's a really interesting issue that goes with the Re-X Corp decision, which is that the challenge is, does British Columbia actually have the jurisdiction to order that content not be accessible out in anywhere other than British Columbia. And there are arguments being made that we have to think about that in the broader context of, well, there may be some regimes who might make those kind of decisions, and we would not want their decisions to be given extraterritorial effect. So a lot of thinking really needs to go into what is different about intimate images and intimate image abuse. What are the issues that are at play that actually merit extended jurisdiction, including sort of widespread agreement in many jurisdictions around the world that intimate image abuse is a very serious problem. So I think that there are issues there is a constitutional issue to be talked about, but I also think there's a really important distinction to be made between intimate images and other kinds of orders.
Absolutely. I'm mindful of the time, so if anyone has got any remaining questions, please put them in the Q&A now. So we've had another question from Annie. Do the laws cover threats to distribute or only distribution? And actually, I'll add on to the end of that, is possession included in any of the laws as well?
So I know some of them cover threats. I can't tell you which of them at the moment. And I do not recall possession being in any of them. Now, possession, of course, we didn't get into this, but images of young people are treated differently for criminal law purposes, obviously, and so possession of an intimate image of a young person has a whole other series of potential consequences. Ghania, I don't know. I'm not aware of anything that covers possession, and that certainly not all of them cover threats.
Yeah, I don't think any of them cover possession. I do remember for British Columbia, the Intimate Images Protection Act, they do have a section on threats. So a person could either bring a claim about their intimate images being distributed, or someone threatening to distribute the intimate images. But off the top of my head, I think British Columbia comes to mind. I think perhaps New Brunswick, but British Columbia for sure has a section on threatening to publish intimate images.
Yeah, with the possession, I always find that quite interesting because we have the same in the UK, that possession threats are covered, but possession isn't. And I always find that so bizarre, particularly when talking to frontline practitioners who speak to, women who have had their images shared, and a lot of them describe wanting the images to be taken off the person's phone or whatever online or digital equipment they have that's hosting this image, and having to tell them that the actually being on their phone, they can't get that taken off, and just living with this constant fear and stress and anxiety that it could be shared again at any other point. I always find is absolutely ridiculous, to be honest, and why it's not being addressed adequately, I don't know. I'm going to be cheeky and ask another question myself. So just going back to the conversations about deepfakes and synthetic material, I'm really interested in, Ghania, you mentioned you use the language dehumanization, dehumanizing earlier on. So where do you think possibly dehumanizing deepfakes sit in this conversation? So for instance, there's examples across the globe, particularly when with what happened with X and Grok, and how it was used, that we had images were created of women being deported, where their race had been changed, cultural attire had been either removed or put on women. So where do you think images like that, for instance, fall in this discussion?
Of course, before I answer that question, I also wanted to quickly go back to the previous question about if legislation includes sections on threatening to disclose someone's intimate images. I think there's also like another host of issues in that section too. I believe there were a couple cases that the tribunal in BC specifically stated that there was no threat, and so I think perhaps like that's also something that needs to be further investigated in terms of like what is the evidence needed in order to prove that there is a genuine threat, and I think that could also perhaps be an access to justice issue as well. And then answering your question, I think in terms of synthetic images, there's just been one case in Canada so far about a trans woman's face being depicted on a masculine body. And in that specific situation, it did qualify as an intimate image. And the tribunal said that it was, dehumanizing and distressing. But given that there is a sense of not wanting to expand the definition of intimate images currently, it's kind of hard to say how other images that change someone's race, that change someone's cultural clothing, will be considered, because the definition of intimate images is very limited, or the way it's interpreted is very limited. So I think the first challenge would be to even prove that it is an intimate image. However, I think perhaps we need to consider that not perhaps intimate image is not the way that perhaps we need to consider that perhaps using the definition of intimate images might not be the best recourse. So perhaps looking at expanding our definition of privacy into bodily autonomy or bodily integrity would be a better way. And I think that could also encompass the examples that you mentioned of, someone changing another person's race or their cultural affiliation. And I think that lends more to bodily autonomy, bodily integrity. But yeah, but currently I think given the interpretation of intimate images, I think the first step would be kind of it would be hard for people to argue that certain images are intimate images based off of just the case law.
And did either of you want to add anything else? We've hit time now, but just if you had any last comments that you wanted to make.
Yeah, I just again like to thank everybody for being here and for the really interesting questions, and that I would love to continue the conversation. I left that slide up because my email address is there. So if you want to reach out to Ghania and me, you can do that. But yeah, absolutely. The right now intimate image legislation is focused on questions of sexual violence, and I think that we're going to have larger discussions about other types of violence and whether the right way is to shoehorn it into this kind of protection, or whether we need to be thinking about other sorts of human rights relief for these sort of online harms. And we're anticipating apparently new online harms legislation to be tabled sort of any time. Sort of stay tuned, and things are, I think all of this is in many ways connected with that.
Yeah, I
Great.
just wanted to thank everyone for attending. And we are also currently working on our website, and so it should go live hopefully over the summer. But I've included the link in the chat in case anyone wants to tab it. But you could follow along on the research project, and hopefully we'll have blogs, publications, and future speaking events as well.
Great, thank you both so much. It was such an interesting presentation. I still have so many questions, so you will definitely be getting an email from me at some point. But yeah, thank you everyone for attending. And yes, have a nice rest of the day.
Thank you.
Thank you. Bye.